Welcome to Devine Intervention, shedding light on Illinois property tax.
Hello, and welcome to Devine Intervention, shedding light on Illinois property tax with Nora Devine. Nora has been a property tax attorney in private practice since 2005. She has developed a statewide practice in all jurisdictions in Illinois, and she represents all property classes. I'm your host, Abigail Vaca, and today's episode is Decoding Illinois Tax Law, Omitted Assessments and Legal Defenses. Thanks for joining me, Nora.
Oh, thanks for having me back.
So let's jump right in. Could you explain what omitted assessments are and how they differ from regular property tax assessments?
Sure. In Illinois, most of the property tax liability comes from just your regular assessment that is published. And then if you disagree with it, you can appeal to the assessor, you can appeal to the Board of Review. Once the Board of Review is wrapping up its work, then whatever the finalized assessment is after the Board of Review appeal process, that's the number upon which your tax liability will be based. From there, the Cook County clerk or the clerk in whichever county you may be in Illinois is going to try to do a calculation based on the levies that are coming in from all the taxing districts in the county. They're going to add up how much money is being requested from the property tax. They're going to arrive at a local tax rate. They're going to apply those local tax rates to the assessed value, and then they're going to mail the bills out. So in a normal situation, you get notice of your assessment. When you receive the notice, that's when it's time to argue about the value. That's when it's time to contest the assessed value. And if you miss that opportunity, then what happens is the tax bill will be computed based on the assessment that was proposed initially during this regular assessment cycle. An omitted assessment is a mechanism by which a county can recoup taxes that should have been paid but weren't paid on either a piece of land and or a building that was not captured in the typical assessment process, which is a proactive process. First, the property is assessed, then the assessment is appealed, then the assessment is finalized, then the tax bill is issued. That's the normal way it goes. But if the assessing officials realize that they didn't have a piece of property on the tax roll and it should have been on the tax roll, or they didn't have a building on the tax roll and it should have been on the tax roll, then the mechanism in Illinois by which the assessing officials can correct those mistakes is called an omitted assessment, which results in a back tax.
And what are some of the typical scenarios that lead to properties being omitted from tax rolls and resulting in those back taxes?
I've worked on dozens and dozens, if not 100 omitted assessment cases in my time. There are many fact patterns that will result in an omitted assessment and a back tax. Number one, if there's a property that is totally exempt from taxation, either because it's an educational use or it's owned by a unit of government or it's a religious use, or it's a charitable use, and then that property changes hands from an exempt user to a non-exempt user. So in other words, the non-exempt user comes to own the property after the exempt user had owned it and had achieved this exemption. Then what happens is there is a provision in the property tax code that requires you to send a notice via certified mail if you want to have a defense from being charged a back tax later. So in other words, you can send the notice, you can decide not to send the notice, but if you don't send the notice and then they find out later that the property is no longer owned by an exempt entity, they can recoup up to 3 years of property tax liability by issuing an omitted assessment that would go back to the date of the transfer from the exempt to the non-exempt entity. So that's one major fact pattern that we see. Another fact pattern is when a property is assessed as vacant land and somebody comes along and builds a structure on that land, and the assessing officials either don't receive notice of that permit, the building permit, or they do receive notice of the building permit many times, and instead of reacting to the building permit and putting the property on the tax roll, they don't process the permit. And so if they had notice, meaning if the assessing officials received a copy of the permit, so if the municipality sent a copy of the permit to either the local township assessor or the county assessor, that should be a defense against an omitted assessment. And that's the kind of research we do when we get those types of properties coming our way with property tax problems. The other way you can have an omitted assessment is if you took a tax advantage related to a homeowner's exemption and you did not qualify for the homeowner's exemption. Inside of Cook County, the omitted assessment statute is the mechanism by which the government recoups the amount of tax dollars that were saved that should not have been saved. And that statutory framework is very draconian, as they say. It was based on the similar type of legislative structure that they have in Florida. And so if you take an exemption to which you don't qualify for in Florida, it's very tough penalties. It's penalties, interest, and it's the more properties you have that you took the exemption that you shouldn't have taken, the more the penalties escalate. So those are the three main categories of omitted assessment in Illinois.
Are there any specific statutes that property owners should be aware of?
Well, yeah, the omitted assessment statute is contained in the property tax code, and there are some significant defenses available for people who are facing an omitted assessment. Since the assessing officials can go back for 3 years, these omitted assessments can be enormous and a huge hardship for the property owner. So if you want to try to avail yourself of a defense that's contained in the statute, you would read the statute, try to understand the defenses that are out there and see if your facts fit any of them. Some of the defenses that come to mind is that if you filed an appeal with any assessing official and you notify them of the correct property characteristics during the course of filing that appeal, and you can prove that you did submit that information, then that should be a defense against an omitted assessment. If you can show that a building permit was transmitted from the municipality to the assessing officials, or from anybody for that matter, to the assessing officials, whether it be the local township assessor or the county assessor, if you can show that that happened, that should theoretically serve as a defense to the omitted assessment. If you are the buyer of a property that was formerly exempt and you did make that notification under the statute, you send it by certified mail, you notify the assessing officials of the transfer, and if they did not act on the notice that you sent and they later try to issue an omitted assessment, the proof that you sent the notice should serve as a defense. And those are the main defenses that I could think of right now.
Got it. I would be curious to hear how the statutory framework and case law has changed over time since you've been practicing in this area.
When I first started practicing, the assessing officials were able to go back in perpetuity. So if there was an old building on a property and it had been there for 30 years, the assessing officials could theoretically issue an omitted assessment for 30 years. And so it had this really chilling effect where, people who knew that they had an improvement on their property that wasn't being properly assessed, they would be very unlikely, almost never willing to come forward and to try to have that improvement put on the tax roll, because it was so open-ended in terms of how far back the assessing officials could go. And then it becomes an issue of fact that is very murky, because what was it worth 30 years ago? What was it worth 20 years ago? You can't slap a value on it that's accurate today and extend that same exact value back year by year all the way back to whenever they think the thing was initially built. So maybe, I don't know how long ago it was, more than 10 years, probably less than 15 years ago, they had a major overhaul of the omitted assessment statute, and they put a cap on how far back any assessing official could go in Illinois. So now it's capped at 3 years. So now when I have to advise a property owner who has some improvement on their property that's not being assessed correctly, I can actually quantify for them what I think the 3-year tax exposure would be if they decide to go and have the assessor assess the property and put it on the roll. I can come up with a pretty tight projection and range of value that may result in a tax liability that they can at least foresee and understand. So that's one major difference, is that they can't go back in perpetuity. It's only a 3-year window now. And the other big difference is that the Board of Review used to have no jurisdiction in Cook County to review omitted assessments. The assessor would issue the omitted assessment, and if you didn't like it, you would appeal to the assessor and say, please reconsider what you did here. But I've been doing this a very long time, and I have found over the years that people don't frequently like to reconsider what they've done. They think that what they did the first time was correct, and they don't rethink what they did. So it's really important that there is an independent quasi-judicial administrative agency that can provide an impartial review of these omitted assessments. So that's a huge difference between how the statute used to be and how it is now. And then finally, there were no defenses really under the previous statute. If, there was, is it there or is it not? That's the question. And if it is, then the assessor really had full authority to assess it however they wanted and as far back as they wanted. Now, there are all these defenses. And it's like, well, wait a minute, did the taxpayer submit the accurate characteristics into the record if they filed a property tax appeal? Wait a minute, did you receive this permit? And if you did, why didn't you act on it? Why are you still assessing this property as though the building's not there? So yeah, there are a lot more defenses now than there were under the statutory framework early on.
I see. So this is incredibly complicated. So when a property owner is faced with an omitted assessment, what initial steps should they take to challenge or mitigate the back taxes owed?
Well, the first thing they need to do is understand the deadlines. If the assessor is still open for filing, then you can file an appeal with the assessor asking them to reconsider the back tax that they're levying on the property. And I have had luck getting the assessor to reverse itself because there are so many employees in the assessor's office, and the one who thinks it might be a good fact pattern for an omitted assessment, they are going to have a different approach than whoever is actually reviewing the appeals for the omitted assessments, because those appeals may be going to the legal department, and the legal department may be more familiar with the ways in which the statute is being interpreted and applied. So there is luck going to the assessor at times. And then importantly, you need to know when the Board of Review deadline is, because if you don't file at the Cook County Board of Review, then you cannot file at Circuit Court or the Property Tax Appeal Board. So understanding the deadlines is critical. And if you don't understand them, you have to check with an attorney who can advise you. There's really kind of one bite at the apple here. If you get denied, you're going to end up in court over the fact pattern. And then it becomes sort of a long drawn out, difficult thing to prove that you should not be subject to the omitted assessment. So I think checking the deadlines is critical. Hiring the right attorney, hiring an attorney that really understands the omitted assessment statute and has had success arguing under that statute on behalf of taxpayers.
This brings to mind another question. How do property improvements or modifications influence the likelihood of omitted assessments? And what should owners consider during such projects?
That's a really good question, because there was a whole body of case law under the old version of the statute. And from what I've seen, there really hasn't been much case law yet on the new statute. So if we're going to refer to the old body of case law, which was construing the old statute, you would need to consider that the bottom line for all those cases is if there was a assessment on the land and there was some assessment on the building, and the tax bill was issued based on that total assessment, the tax bill was mailed, tax bill was paid, then that's not a good fact pattern for an omitted assessment. So in other words, if the assessing official missed an addition or they missed some kind of an improvement that was made to an existing structure, that never really has been a very good basis for issuing an omitted assessment. So I would say people who are thinking about adding onto their homes and things like that, generally omitted assessment is not the way that that's going to work. Where you see it is if there is a new construction on a property that was previously assessed as vacant land, that's when you really have to be concerned about whether or not this property is going to be picked up in a timely way and put on the tax roll.
What about documentation? How crucial is maintaining proper documentation when disputing omitted assessments? And what type of records are the most effective in those types of defenses?
Well, the types of records that work are generally not the types of records that the taxpayer is going to possess. So if you're trying to prove that an exempt property that changed hands should not be subject to an omitted assessment, then the document that's going to work is the certified mail that was sent to the assessing official notifying them of the transfer. And the taxpayer may not have that. It may be the taxpayer's closing attorney who has that document. And if you are contesting an omitted assessment because the assessor actually did have a copy of the new construction permit, but they didn't process the permit and put the property on the tax roll, then the person that's going to have that document is the assessing official. And you can usually find it by way of Freedom of Information Act. And if they say that they don't have it, then you can do a Freedom of Information Act request to the municipality requesting the documents that were sent from the municipality to the assessing officials. And so that's the document that's going to help you under those fact patterns. But usually it's not a document that the taxpayer possesses themselves.
I see, but it sounds like proactivity is something people can focus on here. So what proactive steps can property owners take to ensure their properties are accurately assessed and avoid those future omitted assessments?
If the deal seems too good, then it probably is. And so if you feel like you're getting away with something and you feel like, the taxes should be much, much higher than they are, then you have a decision to make. Do you want to roll the dice and leave the property off the tax roll and see how long you can go without them figuring out that the property should be assessed? I do have clients that have chosen to go that route. And if you can quantify for them what 3 years worth of tax liability is going to be, then that's up to them. They'll put that money in escrow and they'll wait. But my advice to people is always, it's better to have an accurate property record. And I think that the best advice is to put the property on the tax roll if you know that it's not on the tax roll. And that's the advice that I give all of our clients.
I think that's a great way to end today. Thank you so much for joining me, Nora.
Thank you.
And thank you for joining us on Devine Intervention, shedding light on Illinois property tax with Nora Devine. To connect with Nora and the team, visit thedevinelawgroup.com. And please like, subscribe, and leave a review on your favorite platform.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.